There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
Welcome back, guys. Today's sovereign citizen court hearing is straight up chaos. We've got a woman in trouble for violating her probation because of drug use. And of course, she thinks she's her own lawyer. Classic move, right? She starts dropping those typical sovereign citizen lines like, "I don't recognize your authority," and "I stand under common law." Spoiler alert. The judge isn't falling for any of it. Probation violations are serious business since it's basically breaking your second chance. And sovereign citizen excuses. They hold absolutely no weight in court. Zero zip nada. What do you guys think? Should people who break probation while pulling this nonsense face even tougher punishment? Drop your thoughts below and let's dive in.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm gonna make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
All right, state may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss?
Wow, she just completely blew her only chance to defend herself. Like, how are you going to skip your opening statement, the one time you can explain your side? Judges aren't mind readers. I can't tell if she's already accepted she's doomed, or if she actually believes she's too good to follow court rules. What do you think? Let's get back to the madness.
A child underlying 12-month sentence.
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she be
Honestly, she needed an attorney, badly. This is just painful to watch. The judge is dismantling her at every turn, and she doesn't even realize it. I almost want to feel bad, but she walked right into this by herself. Showing up in court without knowing the law is like bringing a water gun to a flamethrower fight. So what do you guys think? Do you feel bad for her, or are you face-palming like I am right now? Let's jump back in and see how much worse it gets.
I would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200.
$1,200 per minute in jail. That's absolutely ridiculous. If she really cared about her kid, she wouldn't have violated probation for drugs and put her child at risk. I have zero sympathy for that. If you can't stay clean for your own kid, you shouldn't be around children at all. She was rude to the judge, disrespectful to the system, and clearly doesn't care about herself or anyone else. Honestly, she should have been hit with a contempt charge for threatening the judge at the end. What did you guys think of this case? It seriously made my blood boil, but I'm curious to hear your thoughts. Let me know in the comments. And if you enjoy breakdowns like this, don't forget to like, subscribe, and stay tuned. I post every single day. Thanks for watching, and I'll catch you in the next one.